Kim Potter, former law enforcement officer, was found guilty of manslaughter in the Dante Wright case. The argument that she made was, I made a mistake. I went for my taser and got my gun. And so the jury didn't see it that way. They might have seen it that way. But the fact of the matter is they still found her responsible for his death, thus the manslaughter conviction. And now, I don't know who to get for a better expert on this than a former law enforcement officer, now turned defense attorney, and one of the top defense attorneys in the state of North Dakota. And that's Mark Friese, a good friend from the Vogel law firm. Mark, good to have you coming down the road with us.
My pleasure to be here.
So when you saw this whole thing, what was your first reaction? When, not the legal side, but just the case of, hey, you've stopped someone, you've got that individual, they're fleeing, and you know, you're in that situation and you saw what happened. What was your first instinct?
It was tragedy. I mean, it was a tragic circumstance. It was obvious to me, and I think it was obvious to any observer, that Kim Potter did not intend to hurt Dante Wright, that she reacted based on her training, but reacted inappropriately and grabbed the wrong weapon.
So a couple questions on that we were bouncing by each other the other night. Number one, taser one side, gun the other, right?
Right.
Okay. Why are tasers shaped like guns?
It's a great question. When I was issued my first one, they called them ERDs, electronic restraints back then. It was like a box that was small, very different. I think because of the projectiles that come out of the taser, and they can be colored black or they can be colored yellow, and they're typically worn on the off side. So an officer who's right-handed will wear their sidearm on the right side and the taser on the left side. But for purposes of continuity of proficiency as it relates to using the weapon, and based on the design that's necessary to shoot out the projectiles, I think that's probably why the manufacturer has them, that they look somewhat similar to a firearm.
So you're the police chief. Now you've not made this transition into defense attorney. Would you want tasers shaped like a gun?
I have to defer to the experts on that, the mechanical engineers and those that have designed and tested them. The officers that I've spoken to, this is a very, very uncommon occurrence to mistake the taser for a firearm. It happens only a handful of times every year across the country. But it happened in a circumstance that was very rapidly evolving, very tense. The jury in the Kim Potter case, for example, talked about comparing the firearm to the taser. They felt very different. The firearm is much heavier. The trigger is different. The shape is different. But in the heat of the moment, as the officer was reacting under a lot of stress, she grabbed the wrong item.
So how long had she been in the force?
25 years, I think.
So there was a big level of experience there.
There is. Joel, I read a commentator who was writing in the immediate aftermath of this. He says, I've been a fisherman for 40 years. He says, the other day I went fishing. He said, I went and caught one of the nicest fish that I've ever taken. He says, I went to take the hook out, and I went to throw the fish back in the water, and I threw my plier back in the water. Mm-hmm. And he says, I've caught hundreds, if not thousands, of fish over the years, and it was just that I did the wrong thing. People put their cell phone in the refrigerator instead of the milk. People just automatically do things mistakenly, even though they've done them 100 times before.
Mm-hmm. And that came across on the stand. I mean, the honesty that both on the defense side and on the prosecution side, I think it wasn't a fake. I mean, anyone who saw that, there's no way someone can fake like that. Or have I gone too far here?
No, I think you're absolutely right. I think any reasonable observer, and some of the jurors are now speaking out anonymously, but they're speaking about their deliberations universally. I think everyone agrees that it was a mistake. It was an honest mistake by an honest person.
So is there no leeway? I mean, is there no leeway that allows them to get to a place where they knew and say, is the leeway just with the judge? I mean, we don't want her in jail for this mistake, but the way the code reads, the way it's at, she was guilty of what they're saying she was guilty of.
There are commentators across the country. Alan Dershowitz, a professor at Harvard Law School, has spoke out very openly about this, that this is not a crime, that this is a mistake. The problem, as I see it, is we have expanded our criminal law so far that we're encompassing honest mistakes by honest people and making them crimes. And it's a dangerous trend. It's a terribly dangerous trend. And it's not just police officers. My law partner and I teach at the law school, and we use some examples with our students about making charging decisions as a prosecutor. For example, the diabetic who is in the middle of a diabetic reaction at the grocery store opens up a bottle of orange juice and walks out failing to pay for it. They technically committed a crime, but there's something else that's driving it. Or the hurried parent who gets to work, know that they have a busy day, and unbeknownst to them or neglectfully, the child's locked in the back of the car, in the car seat, and it's a hot or a cold day, and the child dies. We prosecute those things. We turn that into a crime far too frequently, and it's really using our criminal justice system beyond, I think, its intended aims.
So you're the prosecutor in this case, and the approach that she took was one that I thought was very aggressive. One that I thought looked as though when Potter was at her worst in terms of the agony and the pain she was going through, that the prosecutor just kept going and going. I kept thinking, the prosecutor's going to pay for that, with the jury. There's, if she kept punching her the way I thought she was punching her, I thought, this isn't going to end well for the prosecution. But they won.
The part that we didn't see is the jury selection. Oftentimes, and I ask juries all of the time in virtually every case, and I ask police officers when I cross-examine them, they're trained to deal with tough questions. They're trained to answer questions on the stand, and they're trained, a police officer is trained to be able to act professionally and maintain their professionalism during tough questioning. So I think the jury would have probably been prepared for those questions. What astonished me, though, is at the end of the case, when the jury had rendered their verdict of guilty, the prosecutor moved for detention of the defendant, wanting her to be held in custody till sentencing. The purpose of bail is generally to make sure that the person is going to appear in court and to make sure that the person doesn't present a threat to the public. There's no one that would disagree with the fact that she's going to make her court appearances and that she's no harm or no danger.
Is that standard, though? I mean, is that something that they move for, knowing that the judge wouldn't do?
I think it underscores the reality of this entire case is that the prosecution and the judge, in large part, are affected by the lynch mob that's outside the courthouse, the protesters on both sides of the argument, on both sides of the debate. We have elected prosecutors and elected judges, and we have to balance accountability. The judge, we want to hold the judge accountable and vote them out of office if they're not doing a good job, versus independence. We would like to have a judge or a prosecutor make an independent decision saying this was a mistake, even though it may fit the technical definition of a crime, which many dispute it does not. Even though it may fit the technical definition, the judge and the prosecutor should have discretion not to charge, not to remand into custody pending sentencing, to deviate from what the sentencing guidelines may say as well.
Mark, before the break, we talked about the jury itself. Should they have been sequestered?
In a case like this, I think they have to be. The media attention is pervasive. The courthouse is surrounded by people advocating for one result or the other, and that would undoubtedly impact and influence how the jury views their role.
In your experience, has a jury that's been sequestered, are they in deliberation together long before they should be in deliberation together?
We don't know. We only know from anecdotal information, from polling the jurors afterwards, or from research. For the most part, I think juries do a very, very good job of following the instructions of the judge. And the judge will invariably and repeatedly tell the jury, you cannot discuss the case, you cannot deliberate until the evidence is closed, and I've given you instructions. Feel free to talk about the weather, talk about whatever you would like, but don't talk about the case until it's time to do so. And jurors take an oath. And in my experience, they do their very best to follow that oath.
So as a defense attorney, you're sitting there when you're not questioning, when the prosecution is doing their job, my assumption is you're going to look at that jury. It's a poker game. You're going to look at them. Is it easy to tell, because oftentimes they talk after the trial, is it easy to tell who is the leader, who's the follower, who you have at least looking at your argument, and you can see in their eyes that they're at least considering that.
No, it's
Really?
it's difficult. I can
That's surprising to
occasionally,
me.
in fact, I
I
probably
wouldn't want to play poker against you, is my point. So it's surprising.
the jury four-person. I'm probably more predictable in identifying who's a leader, who's got the strong personality, than exactly which way they're going to go when they get into deliberations. I've been very surprised by some jurors, and in other instances, jurors have been predictable. But you really don't know. We all bring biases and prejudice with us wherever we go. We just don't know how those are going to play out in the jury room. So we try to do the best to ask questions that we can, but it's tough to predict how they're going to ultimately decide cases.
We see so much of this on TV. And my guess is you're ripping your hair out when you're watching it on TV. You know, the approaching the witness, the what I would call harassing, the means of how they determine who the juries are. I mean, as a defense attorney, do you have the ability to do all kinds of research on Joel Heitkamp and say, I need to know about this guy prior to whether or not I've got so many refusals here, and this is one I don't want on the jury. Can you do those type of things?
Tons of it. Social media is it's a treasure trove to look at people and their background and their ideas and their dispositions and predilections. We sometimes hire an investigator to run searches and to do more background information. Depending on the nature of the case and the resources of the client, is going to have an impact on how much of that the client can afford. I'm
going to give you one story. I got called to jury duty once. I actually got called more, but once they found out I was in media, they didn't want me, which thank God. But the first time I got called to jury, I was back in my rural water days, and there were 60 people called, which I thought was a really big number. 18 people drawn out of the hat. I was the 60th one on the roll call. I mean, and they didn't do it alphabetically. It was like, okay, Heitkamp, are you here? I was the first one drawn out to be a juror. So that day wasn't a day I wanted to play poker. So I'm sitting there, and my cousin, Bob Heitkamp, got drawn out too. He wanted to be on that jury. You could sense he wanted to be on that jury. It turns out he worked with the guy. And so the defense attorney's asking us about each other, and and I'm basically giving them every reason to send me back home. And Bob's going, oh no, I can, hey. Then they go, well, hey, you work at Kitchens Unlimited, and this guy works at Kitchens Unlimited. And the judge said, you're excused. And then he looks at my name and he goes, your name's Heitkamp too. And I said, yeah, I live right across the street from him. And they go, you're excused. And I'm like, can you sense when somebody desperately wants to be on the jury?
I do more than that. I regularly ask if there's anybody that really wants off or really wants on the jury. And there may be really good reasons to want to serve on a jury. You want to fulfill your civic duty. You would like the experience. You have an interest in the law. You have an interest in the case. And there may be very good reasons to not want to serve. We had a federal death penalty case here in North Dakota not that many years ago, and there are a lot of people with very firm commitments against or for the death penalty. So there are a number of reasons why jurors will want on or off. And we have, as lawyers, I think we have a tendency to pick the people in the middle of the road, the ones that will serve if they're asked to serve, but they don't necessarily really want to be on or off.
Do you ever have interaction with them afterwards? In the Gordon Call trial, someone from Hankinson that I knew quite well, he's gone now, but he was on that jury. That was life-changing for him. That was a moment that you couldn't get into a conversation with him later where it didn't come up.
It's very customary for the attorneys to poll the jurors after, call them, to ask questions. Okay. What evidence was most compelling to you, the things that you could offer to me to help me become a better lawyer, any idiosyncrasies or any concerns that you have, overall impressions. And most judges will tell the jury when they finish their duty, the lawyers may call you. You're free to answer their questions if you want to. You're free to decline.
I want to go back to the Potter case. What do you think the sentence is going to be? I mean, if you had to make a prediction, what are we looking at?
The maximum sentence, and he was convicted of 2 counts: manslaughter in the first degree and manslaughter in the second degree. The first degree manslaughter in Minnesota has a higher maximum penalty, which is 15 years. Minnesota uses a sentencing guideline mechanism where they'll take the criminal history, the person's prior background, and they'll interpolate with an offense level and come up with a presumptive sentence within the guidelines. And in Minnesota, for first degree manslaughter, it's 6 to 8.5 years. So the bottom end of the guidelines, 6 years, top end of the guidelines, 8.5 years. Maximum penalty is 15 years. The prosecution is going to be moving for an upward departure, asking the judge to impose a harsher penalty, alleging that Ms. Potter abused a position of authority or used extreme recklessness. And the defense is going to be moving for what they call a dispositional departure in Minnesota. They're going to ask the judge to depart downward from the guidelines because this was a mistake. She has a very unblemished record. The circumstances were not contemplated. They weren't volitional. Those types of things. And it would not be surprising to me that the defense would ask for a period of incarceration locally rather than in a penitentiary, so a local correctional center or electronic monitoring or probationary disposition. That's a long answer to your short question. My guess is the judge is going to impose a safe sentence, meaning somewhere within the guidelines.
So you're talking about could be 6 years.
6 to 8.5, probably.
Wow. When it's 6 to 8.5, how long before she's eligible for parole?
Minnesota does not do parole like North Dakota. Minnesota does a good time calculation. So the general rule of thumb in Minnesota is that whatever the sentence is, she'll serve 2/3 of it incarcerated, and then the remaining 1/3 will be on a probation or a parole type programming.
Is there any consideration whatsoever that you're putting a law enforcement officer in jail with people that were put in jail by law enforcement officers?
There is, but oftentimes judges will defer to the correctional authorities for safekeeping or safety protocols. More simply, the judge is going to say, yes, I understand you're going to have conditions of confinement that are much more stringent, much more difficult, that you're going to be outcast by the population, but I trust that the correctional authorities will put you someplace safe and try to isolate you from that type of danger that you're going to experience.
How does she get found guilty on 2 counts? If there's one shooting, there's one person that was killed.
That's a great question. And a lot of my colleagues have asked that same question because North Dakota does it very differently. So the prosecution can charge in the alternative, and they did. They charged both first and second degree manslaughter. The first degree manslaughter is more culpable. It requires a higher level of culpability. Because the jury convicted of the first degree manslaughter and the second degree manslaughter, the judge will disregard the second degree manslaughter conviction at sentencing. North Dakota, we really do the opposite. We ask the jury to make the decision. We give them a verdict form, and if there isn't a first degree manslaughter in North Dakota, but if there were, they would first find whether they're guilty of the first degree manslaughter. If they conclude that she was guilty of that, they stop, and they don't enter a conviction on the second.
So you're her defense attorney, and you're going to make a case on appeal. What's your case going to be based on?
I think that the practical reality is the best defense at all. This was an honest mistake by an honest person and isn't criminal conduct. This is not a volitional act. She didn't get up that morning, put on her uniform, and decide she was going to go out and hurt somebody. She had no intention of doing so. It was a very benign reason for the stop. She was training a younger officer who had actually made the stop. And the circumstances are such that she simply made a mistake. The volitional acts, the intentional acts in this case, were the decedent, Mr. Wright. He had an active arrest warrant for him. He attempted to flee. He placed the officers and bystanders in the community at risk by trying to flee from a lawful stop. I think an appellate court is going to have a tough time affirming the judgment of the jury under the circumstances that were presented at trial.
All of that is bad news for me. I mean, for me, it doesn't shock me that she was found guilty. What does shock me is 6 years potentially. So, Mark, thanks for coming in.
My pleasure.